Welcome to our next episode of Rock the Closing. Today we are talking about something extremely important. This is the contract negotiation process. Without this, we have nothing. We have no deal. We need a contract, and that contract needs to be negotiated. So let's talk about it. Orsolya, where does it all start?
Hi, Dalia. Everything starts with the deal sheet. Okay, the deal sheet contains all the basic information of the parties, what property is under sale, which property is going to be sold. And it also contains the information regarding the attorneys. So one way to start a transaction is to receive a deal sheet either from the broker or either from the parties, or if there is no broker involved, then the two parties, the seller and the buyer, may just share with one another the contact information for their attorneys. So, for example, the way I am starting this type of communication is when I receive a deal sheet or the attorney's information, I always send out a courtesy email and I say, hey, I am your partner on this negotiation process and I'm looking forward to working with you on this transaction. Then I usually get a response to that. What may happen at this very, very initial stage is that the other attorney might be CCing the people on the email because I may just have the attorney's email, but he might be adding some other staff members who will be in charge on working in that transaction. And that means from that moment on, going forward, you will be basically communicating with the entire team. So initially starts with a deal sheet or exchange of attorney information. Then there is usually an initial courtesy exchange when the two teams get introduced to one another. Again, very basic. This is where we start from. Dalia, when is the contract negotiated?
So we're going to be negotiating this contract basically as soon as it's drafted. Okay, so like you said, it's drafted with all the basic information. So we're going to start negotiating it, obviously, before it's signed, before anything happens. This is the first step here. So it's going to go back and forth between the seller and the buyer's attorney, tweaking things, changing terms. We're going to be negotiating this before any money is sent to the seller, before any down payments made. It's really the first step. We need this to have a deal. So it's as soon as the deal sheet comes in, we have that contract, we start negotiating right away because we definitely want to know if we even have a deal. You know, there might be some huge miscommunication between the brokers or something, and we need to know that firsthand. So tell me, Orsolya, who prepared the contract?
So the contract is always prepared by the seller's attorney. And how does it work? So you receive a deal sheet or you receive the basic information. And what I do usually if I'm representing a seller is I always confirm that the information on the deal sheet is accurate. Again, referring back, we had an earlier podcast on the deal sheet, but just a gentle reminder. So I like to confirm with my seller, is this your correct name, your correct address? Is this the price? Did you agree that the buyer is taking out a mortgage? What's the amount? What are you excluding or what are you including in the transaction, and so on and so forth. So first, the seller's attorney usually confirms the information. If I am representing a buyer, I also confirm it with my buyer that all the information is correct. And this is what he agreed to, what's in the deal sheet. When this confirmation has been accomplished, the seller's attorney will be preparing the contract based on the information provided, and then sends it to the buyer's attorney. It's a draft. At this point, when the draft contract is going out, it's a communication between the two attorneys. We are not initially, at least I am in my practice, not sharing the initial contract and rider with my clients. However, I always include a disclaimer, which is that everything I'm sending, every document, remains subject to my client's review and approval. And it's not an offer and it is not binding. Disclaimer basically means that I'm starting an initial negotiation process, but whatever is achieved during this negotiation is reflecting what's in the deal sheet. However, I will still need to discuss every single detail with my client before I can agree to the final language, to the final wording. So this is how the contract is prepared and the whole negotiation process is started. But I have mentioned here a couple of terms which are important. One is that preparation of the contract and the rider. Dalia, could you bring some kind of clarification to our listeners? What is the difference between the two documents?
Okay, so that's a good question. I feel like both of these things are important. Obviously, the contract, as you just told us, is the basic document, right? It has all the basic terms. So all the things that you just mentioned, they're all in that contract. Aside from that, okay, we as the seller's attorney and or the buyer's attorney may opt to include in the contract a rider, right? So this is something that you're going to send to the other side for their review. And the rider has additional terms that are basically specific to this deal, right? So they may be something like, inspection is waived or, a certain time frame in which closing needs to happen. There may be a credit to the buyer of some kind because of some condition on the property that was found out at the inspection. There may be a post-occupancy agreement. There may be an agreement that certain furniture is staying, or there's like a purchase, a side purchase for furniture. Whatever the case may be that has these specific terms that you don't want to sort of like cram in and handwrite into your like form contract. Those are the things you want to put in the rider. Okay, so whether you're the seller or the buyer, you want to look at what are the specific needs of your client pertaining to this deal outside what the basic contract states. And then you want to put that in a rider and send it over to the other side and, just kind of include it as part of the negotiating process. A lot of times that's something that is negotiated even more so than the contract itself. So tell me, how long does it take to negotiate and finalize one of these contracts?
I would say that usually it takes a week. But it doesn't take a week because there is so much to be discussed or negotiated. It takes a week because it's a slow process. And as we mentioned in previous podcasts, the purchaser's attorney will be most of the time conducting the due diligence. So some terms in the contract cannot be finalized until the due diligence is done. What am I referring to? So for example, the buyer's attorney is always confirming the maintenance amount, the common charge amount, the assessment amount, the flip tax amount. They're confirming it with management. So this will take some time. Then there is an inspection taking place in most cases. During inspection, the inspector may discover something. So this is discussed between the buyer and the buyer's attorney. And then buyer's attorney might be coming back to the seller's attorney that, hey, inspection revealed this and this issue. We would like to include in the contract an additional paragraph relating to, for example, repairing a faulty thermostat. So then that also takes away some time. But to be honest, I would say that from the beginning till the end, it's usually about a week or 5 days. Of course, also depends how much work both attorneys have and how quickly they respond to one another's emails, how much pressure it is to sign the contract as soon as possible, how quickly inspection and due diligence can be accomplished. Again, these are factors, but I would say between 5 days to a week would be realistic to negotiate a contract. Let's say we have a contract and it has been also discussed between the attorney and the clients. How is a contract signed? That's an interesting question, I think, Dalia.
Good question. So now that we have the finalized version, we need everyone's signatures. So typically what happens these days is that the contract is electronically signed. All right. A lot of times these contracts need, 4 people to sign them. And it's very time consuming if we're going to pass around this one piece of paper to all these people in different locations for wet signatures. So we do try to encourage, and it's kind of customary now for electronic signatures to be accepted. It used to be the case way back in the day. We used to go and have sit-down signatures. I remember years ago, long before COVID, clients used to come to the office and we'd review the contract and then we'd sign it. as the buyers, mail it over to the seller's attorney and wait for them to get it and sit down with their clients. And so this process definitely took longer, years ago. And I remember sometimes I couldn't get, if it was a husband and a wife and somebody worked late nights, I couldn't get the two of them together. I would just sometimes go to their house after dinner time and sit at their table and say, okay, when are you both going to be home? And let's sit down and sign this contract. So it's kind of like used to be, do what you got to do to get this signed. And now it's so much easier because people can just sign it right on their smartphone. So that's typically how we're doing the signings now. So it's much easier now. So the signings are pretty easy, I would say, Orsolya. How difficult are the negotiations?
I would say that most of the time it's very standard and very amicable between attorneys. I mean, obviously, both parts are protecting their client's interests. But attorneys also want this contract to be finalized and to become a binding agreement between the two parties. So it's in our interest to push forward our client's interests. And I would say that 95% of the time, it's really a collegial exchange between my counterparts. And while it might take a couple of back and forth in terms of the language, we usually are able to iron it out and come to a very good agreement. I have had on the other side very difficult attorneys who have their own writer, which are like 12 pages long, which I would say are excessive and, try to make commitments and obligation for one or the other party that might not be necessary. But even with those colleagues, we always hit a friendly tone and we come at the end to a conclusion. Another issue that might make negotiations difficult might be if an attorney is non-responsive. Some attorneys are extremely occupied or they are handling not only real estate matters, but they do rather have a general practice and then they just take on so many cases that negotiations are slow. So I would put that in a difficult negotiation process. But again, not because of the content, but because of non-responsiveness on the attorney on the other side. But again, we can also work that out and nudge it a little bit along. There are ways to do that. Again, I think attorneys are friendly, they are colleagues, they are professionals, and I have had in my practice 95% really, really excellent experience with my colleagues and my counterpart. Dalia, since we're talking about contracts and difficulties, are there any good stories you would share with our audience?
I do have a good story. It's kind of a funny one, and it's not the norm, but it's just an example of how, sometimes you think something is going to go one way and you just have to roll with the punches when it comes to contract negotiation. So I had a seller selling a house in New York. And prior to negotiating the deal, he decided to move to Florida. So that's all fine. However, he was not very tech savvy, very, very smart guy, just not very tech savvy. He didn't have a computer. He did not have access to email. He did not have a smartphone. And so it was extremely difficult to, send him, communications where I'm trying to talk to him about certain terms, changing certain terms, and definitely signing was an issue too. I don't even think he had voicemail on his flip phone. So anytime I needed to go over terms with him, I would have to be on the phone with him, reading terms and changes and discussing the negotiations. And, we had to use a fax to have the contract sent back and forth to him and myself. So I would be on the phone with him and he would be standing next to a fax machine and I would send it and I would hear it being sent. Then he'd take it home and he would let me know what time the next day he was going to be going back to the site of that fax machine so that we can get back on the phone and he can send it to me and verify that I got it. So that's how that signing went. It was interesting, not the norms, but you got to do what you got to do for your clients. I mean, everyone's got sort of different capabilities. Some people still really want to sit down with you at a table and sign it. Some people, they're thrilled to sign right off on their phone. And some people just have tech difficulties where it's somewhere in between. So that's my funny story regarding difficulties in signing my contract. How about yours, Lilia? Anything?
Yeah, now that you mention it, actually just came to my mind that I had a lovely client, really lovely, very intelligent, very nice client. We had always this after-hour conversations because he was working late and he could just, embark on having a conversation with me when he was done with his work. And yeah, it became a regular thing that we hop on the phone. I was already done with work and he would just call me up out of the blue. And then I sent him during the day. So this is what was proposed, counter-proposed to my proposal. And then he called me up and he says, no, I don't accept. I don't want it. No, let's walk away. So every counter-proposal that was proposed, it was a minor thing from my counterpart attorney. My client just refused to agree to it. And then the attorney came back and was like, what did I say wrong? What was wrong? What did I do wrong? Why is your client walking? And I just had to say, look, my client is very insistent and this is how he would like to see things to proceed, and he's really not ready to negotiate or be flexible. And it was really minor issues, minor points, but we walked and we had to negotiate with 6 different clients before we went into contract.
Oh, wow.
We got an attorney and the client who just agreed okay, we do whatever your client wants. We want this property and let's just do it. So sometimes it's not the other attorney on the other side. It might be the client who makes negotiation process quite difficult. Anyway, thank you so much for listening to us. This was just really a snapshot about contract negotiations. Thank you for listening to Rock the Closing. Looking forward to having you on our next episode. Bye for now.
Thank you. Thank you for tuning in to Rock the Closing. This podcast is hosted by real estate attorneys who offer valuable insights. Please remember that the content is for educational purposes only and does not constitute legal advice. Always consult a qualified professional before making any decisions. This podcast is copyrighted by Rock the Closing, and any reproduction, syndication, or rebroadcasting of the content requires written permission.